Good morning everyone and welcome to today's webinar, a briefing on rights of light following a High Court decision in Beaumont Business Centres Limited and Florala Property Limited. My name is Stephen Smith, I'm the Country Manager at Stewart Title Limited, and I'm delighted to be joined today by Philomena Harrison, who will be leading today's session. I'm sure many of you will be familiar with Philomena, but just by way of brief introduction. Philomena is an experienced property litigator. Her broad experiences encompasses all aspects of property law and related professional negligence claims. It also includes general chancery and commercial litigation. She regularly advises companies, including banks, financial institutions, and various individuals on a wide range of property and landlord-tenant matters. Her practice is predominantly court-based, and she appears in the High Court, County Courts, and the Court of Appeal. Recommended for Real Estate and Chambers UK Bar Guide since 2004, and for property litigation in the Legal 500 since 1997. Philomena has been described as a highly respected property litigator who is fiercely intelligent and very commercial. She has appeared in major reported cases on rights of light and the assessment of damages in lieu of an injunction. Philomena, good morning and welcome.
Good morning, Steve.
Hi. Just before we get started, I just wanted to very briefly take people through the control panel. I believe for most of you, the control panel will be on the right-hand side. You are listening by default using your computer's speaker system. If you would prefer for any reason to join over the telephone, you would just select telephone or phone, however it's listed on your control panel in the audio pane, and the dial information will be displayed. I believe most people will be dialing in from the UK, so there is a toll-free number if anyone is experiencing any issues with the audio or sound. And if they are and they can't work it out, then please feel free to get in touch via the chat function at the bottom of your panel. You will have the opportunity to submit text questions to Philomena by typing your questions into the questions pane of the control panel. You may send in your questions at any time during the presentation, but what we intend to do is collect these all at the end and address them at a Q&A session at the end of today's presentation. Philomena, I think you were you were saying you were speaking for about 30 minutes today, so we'll take the questions after that. Anyway, no one's here to listen to me, so without further ado, I will pass you on to Philomena for the main part of today's presentation. Over to you, Philomena.
Good morning, everyone. In the middle of the COVID-19 pandemic, now is surely the time for a little light relief. Sorry about that. On the 13th of March of this year, the High Court handed down a much-awaited judgment in a right-to-light case, Business Centres versus Florala Properties Limited. The judge was a deputy, Mr. Peter Knox QC, and the case had been heard at the back end of last year, over a period of 6 days in October, with many expert witnesses. So the loser, who was the developer defendant, is going to be picking up an expensive legal bill, or its insurers will, unless there is a successful appeal. Before looking at the facts of the case in a little more detail, I'd like to say a few words about rights of light cases generally. It's quite rare for cases of this sort to come to a full hearing. The Beaumont case considered a whole gamut of issues involved, not just the issue of whether the developer was liable in nuisance, but also what remedies Beaumont, the successful party, was entitled to. There had initially been issues about the scope of the prescriptive rights that Beaumont claimed, but by the time of trial, those had largely gone. There are a couple of reasons why these claims are rare. The parties often reach an early negotiated settlement, or there is an early legal skirmish, like an interim application of some sort, and a settlement is reached on the back of the outcome of that. There's another reason why they're comparatively rare. A lot of you will be aware, or certainly the lawyers will, that a right to light is an easement. If it is infringed to an extent that is actionable in the courts, then that is a claim in the common law tort of nuisance. But unlike other easements, for instance, rights of way, where an infringement is easier to recognise and prove, rights of light claims get highly technical. This is because the right to light surveyors, who are used as experts, resort to what is known as the Waldron method or test for two broad purposes. First, and principally, to calculate the part of a room that's well lit before and then after a development or proposed development. And secondly, on the basis of those calculations or diagrams, they calculate a form of compensation for any relevant losses. I'll be returning to the Waldron method a little later, but you may remember that it's 10 years since there's been an important case on rights to light. That was the somewhat notorious case of HR UK Limited and Heaney, which caused something of a ripple in the industry when Mr. Heaney obtained an injunction requiring a cutback of the development. In the meantime, and by way of an introduction, I also need to mention an important case in the Supreme Court, Coventry and Lawrence, or the Fen Tigers case in 2014. This was also a nuisance case, but the relevant nuisance was excessive noise, not a breach of a right to light easement, infringement of a right to light easement. Its importance to what we're looking at today is that the Supreme Court considered the test for the grant of an injunction as a remedy for nuisance. One of the reasons why the Beaumont case is significant is it's the first decision since Coventry and Lawrence in 2014 to declare that an injunction requiring the cutback or demolition of an interfering part of a building is an appropriate remedy in a rights of light case. Beaumont established that the reduction of light caused by the development of a neighbouring building on the corner of London Wall and Moorgate in the city had caused a substantial interference with its rights of light. So it established its claim in the common law tort of nuisance. The court then decided Beaumont was entitled to an injunction requiring the developer, Florala, the neighbouring owner, to cut back its development, or to negotiating damages in lieu of an injunction to reflect the amount that would have been agreed in return for giving up its rights to light. So in the light of that decision, should developers, insurers, or rights of light professionals be starting to panic? Well, we need to consider the case in a little more detail to come to a conclusion on that. So I'm going to need to spend a little time on the facts of Beaumont. And I need to go back to 2012, when a closely related company, Beaumont London, which is in the same ownership as Beaumont, had developed and refurbished its own property, including putting in a sixth floor. That development became important in the trial. Since then, the property had been let as a high-quality serviced offices. Before Beaumont finished its development, Florala acquired the property to the north of it. Beaumont had been discussing the loss of light caused by its own development with the previous owner of the property acquired by Florala, and the discussions continued with Florala, which intended to develop its own property in a way which might interfere with the light to Beaumont's property, and that, of course, was what was the subject of the litigation. Florala applied for planning permission to turn its property into an apart hotel. Beaumont then sold the freehold of its property to an institutional investor, which granted a 15-year lease back to Beaumont. Under a rights of light deed, which featured in the case, it was agreed that Beaumont London would retain any rights to light claims for increases in the height of Florala's building up to 11.25 metres, but that the rights would belong to the institutional purchaser if Florala's development was higher. Florala obtained planning permission for its hotel, which would involve it in extending into a light well between the properties and raising the height of the rear elevation. Those works were carried out in 2017 and 2018 and resulted in a loss of light agreed by the surveyors as 270 square feet, or on an equivalent to first zone or EFZ basis, in rooms on the ground to fourth floors. The development didn't go above, didn't increase the height of the building by more than 11.25 metres. However, while the works were still in progress, Beaumont began the proceedings which led to the trial, seeking an injunction and damages and a cutback of the works that would result in all the light taken away being restored. And the other important fact to bear in mind is that in December 2018, so not that long before trial, Florala let the hotel on a 15-year lease to another company. So the decision, it's a very long judgment, over 74 pages. There are essentially 5 headline areas or points to take from it. The first substantial decision that the court made was on the test for nuisance. And the judge decided that in order to establish its claim in nuisance, Beaumont needed to prove that by virtue of the reduction in light, its premises had been made substantially less comfortable and convenient than before. In practice, that meant it had to show that by virtue of the reduction, it was likely to suffer a loss of rental income over the balance of the term of its lease in an amount that was more than trifling, or to use the Latin term, more than de minimis. It was therefore irrelevant whether the premises were well lit within the definition used by rights of light surveyors before the reduction in light caused by the works. And the court also approached the question of remedy on the same basis. If Beaumont could establish its loss, it was entitled to all those losses, held the court, or an injunction to the full extent needed to restore the light lost without having to make an allowance on the basis that some of the light could have been taken away in any event. The second broad area was on the extent of the reduction in light. An important feature of the case was that none of the rooms in the affected part of Beaumont's building on the ground to fourth floors facing the light well moved from being well lit to badly lit as a result of Florala's works. All of the rooms, save for 2, started off as badly lit. There had been a perceptible reduction in light, but that did not necessarily mean that it was sufficiently substantial to amount to an actionable nuisance. Beaumont had to go further and demonstrate that it had suffered an actionable injury. So the third broad issue was how the court came to a conclusion on that and how it assessed the impact of the reduction in light on lettability. Well, the court found that rentals had gone down on each of the first to the fourth floors, partly as a result of the reduction in light, and partly as a result of work on a new development to the south of Beaumont's property, and also to new competition in the market. The reduction in light in the affected areas on the first to fourth floors caused, at least to some extent, a reduction in rents from July 2017, and the court found it would continue to do so in the future. So it held that Beaumont had established that the reduction had caused a substantial interference with its rights of light, such as to amount to a nuisance. There was a substantial interference causing a nuisance, even if Beaumont could restore most of the light by changing the windows in its building. The fourth area, and quite an interesting part of the decision, was the decision on compensatory damages and how the court went about that exercise. The court found that the rentals for the first to fourth floors had dropped by about 2.5% as a result of the reduction in light. That gave an annual loss of about £20,000. The agreed multiplier was 12, and the court awarded common law damages assessed in the sum of £240,000. I'll come back to that a little later. The fifth, and perhaps the most interesting or important area of the decision, is how the court decided the question of whether to grant an injunction or damages in lieu. The burden was on Florala to show why an injunction should not be granted. Beaumont did not have to show that Florala had committed a deliberate breach of Beaumont's rights, knowing that that was what it was doing. As between Beaumont and Florala, Beaumont was entitled to an injunction of the court requiring Florala to cut back its development. It had gone ahead knowing of the risk it was taking, and it had acted in an unneighbourly fashion. Furthermore, Beaumont's injury was not small, nor was it easily quantifiable. The court found it was not oppressive to order a cutback. In fact, Florala did not attempt to argue that it would be oppressive, did not put in any evidence as to the expenditure to which it would be put were it had to undertake that exercise. No doubt Florala would lose some profit, but as the judge held, there was nothing oppressive in that. Beaumont's failure to apply for an interim injunction was not a significant or strong factor either. Beaumont had put Florala on ample notice that it would seek an injunction. It was not required to expend further money applying for an interim injunction, although it would run the risk that at trial it might be considered by the court to be oppressive to grant an injunction. One of the points relied on by Florala in its arguments as to why Beaumont should not obtain an injunction was that Beaumont had not opposed Florala's application for planning permission. The judge rejected this point too, but it's interesting to consider how he did so because it has potential impacts for future cases, in my view. He held that if Beaumont had been seeking an order for the demolition of the hotel, the entire hotel, or a cutback that would have made the hotel inoperable, then the fact that the hotel had planning permission, which Beaumont did not oppose, could be significant. I think this will be an area to be developed out in the cases. But ultimately, the court held that if Beaumont wanted an injunction, it would have to join the hotel tenant so that the hotel tenant could be heard on whether the injunction should be granted. But to cover all bases, Beaumont was entitled, said the judge, to negotiating damages in lieu of an injunction as an alternative to compensatory damages. And the court assessed those negotiating damages in the sum of £350,000. That was the sum, found the judge, which Beaumont and Florala, acting reasonably, would have agreed in return for Beaumont giving up its rights. Florala's hotel was worth about £1.1 million more than the hotel that it would have built if it had been constrained by Beaumont's rights. And the appropriate percentage of that figure that Beaumont should receive was just under 1/3. So before looking at the way forward on this case, I'm going to go back briefly to the Waldron method or test that I mentioned earlier. I said I would return to Mr. Percy Waldron. The Waldron method, apologies, many of you will be familiar with this, estimates the amount of direct sky which will reach a hypothetical table 2 feet 9 inches high in a particular room. And a room is regarded for the purposes of the method or test as adequately lit for all ordinary purposes if 50% or more of its area receives not less than 1 lumen of light or a 1-foot candle at table level. This is the so-called 50-50 rule. And in 1923, in a publication entitled The Illuminated Engineer, Mr. Percy Waldron suggested that the grumble point, meaning the natural illumination at which average reasonable persons would consistently grumble for ordinary purposes, comparable with clerical work, was 0.2% of the light which would fall from an unobstructed hemisphere of a uniform sky onto a flat roof. However, a word of warning here. Waldron is merely a useful guide and not to be applied rigidly without regard to the shape and size of the room or the disposition of light within it. The proportion of the room which receives the required amount of light is determined by rights of light surveyors, or now in reality, a sexy computer program, which creates a light contour map known as a Waldron diagram. There are a few, and they're a bit of a dying breed, who can do the whole process manually. And one rights to light surveyor, who I won't name, boasts that he can walk into any room and tell you where the grumble line will be and be accurate to within about 10%. The Waldron process or method has been the subject of much criticism. From an early stage, in fact, in the 1930s, its limitations were recognised. It's scientific, but up to a point. The selection of a point halfway back in a room is somewhat arbitrary, and it will be extremely misleading if applied to a room of unusual depth or with windows of unusual height. Moreover, as the years go by, higher standards are expected for comfort. And nowadays, to read comfortably, what's required is about 2.5 times the amount adopted by Waldron, i.e. 2.5 feet candles or 25 lux or 0.5% sky factor, as opposed to the 1 foot candle. The right to light surveyors take this material to calculate the total of well-lit areas in any given space as a proportion of the first zone, using the abbreviation EFZ, which we know stands for equivalent first zone. It assumes that the importance of the light lost is greatest near the window and least at the back of the room, and splits the room into 4 quarters as you get further away from the window. So in the first zone, it multiplies the amount of light lost by 1.5. In the second zone, by 1, so it treats it as 1/1. In the third zone, by 0.5, and in the fourth zone, also known as the make-weight zone, by 0.25. In essence, the formula works on the assumption, as I've said, that the loss of light in the first quarter is the most important. Now, although its limitations are known, the Waldron method is still being used in the courts. The judge in the Beaumont case found that it was useful, although on the facts, the so-called 50-50 rule was irrelevant because you'll recall none of the rooms or floors moved from being well lit to not well lit. And in any event, the court found that the tort of nuisance does not require this. But the judge added, and I quote, "I do not accept that I should ignore the Waldron tests. They have stood the test of time and have the advantage of giving one some measure of the loss of light. But I accept that in a case such as this, where the reduction in light is not great, its results provide only a starting point in the inquiry as to whether there has been an actionable interference." The Law Commission has proposed some fairly extensive reforms of the law in relation to rights of light, but hasn't made any proposals regarding these particular limitations. So it's still here for the time being. But in Beaumont, the judge also considered radiance analysis evidence, and he found that this bore out Beaumont's expert surveyor's proposition that the overall level of light had dropped and made the rooms feel more like lower level rooms before Florala's development. Before leaving the topic, and I said I'd come back to compensatory damages briefly, neither party in the case sought to rely on the conventional calculation of compensation used by rights of light surveyors. That is, to take for the last 20 years the value of the loss of a well-lit area to be £5 per square foot, even in the city, and adjust by applying a multiplier to that figure. That approach is to be welcomed, although the court in Beaumont then had to embark on a complicated valuation exercise to determine the impact on lettability, described by the judge as the most difficult part of the case. An appeal. Well, it's believed Florala is seeking permission to appeal. It's still relatively early days, and COVID is interfering at least a bit in the progress of litigation. It's understood that Florala is seeking an extension of time in which to apply for permission to appeal in the current circumstances. In my opinion, permission is almost inevitably likely to be granted, given the issues in the case, and also the relatively low test to obtain permission. So what are the likely areas for any appeal? Well, the first obvious area is that in my view, Florala may seek to challenge the finding that if a development makes a poorly lit building even less well lit, then that can be a nuisance. It's an important point for an authoritative appellate decision, but I don't think the ground will succeed. I think the Court of Appeal is likely to follow the Irish cases relied on by Beaumont. Ultimately, this sort of point sits ill in the mouth of the wrongdoer who's made a bad situation even worse. Just because a building is already poorly lit, that shouldn't mean it can be made worse with impunity. Also, the most difficult aspect of the case, according to the judge, the assessment of common law damages, may be susceptible to challenge. This is because the judge largely rejected the main valuation evidence relied on by Beaumont. Their expert valuer, Mr. Jones, has been putting forward an annual loss in rental due to the loss of light of nearly £103,000. The judge largely preferred the approach of Mr. Shortall, who was Florala's valuer, but nevertheless still rejected aspects of his evidence. But the importance is that in assessing damages in lieu, so not compensatory damages, the court looks for a relationship in amount between the size of the common law damages and the damages in lieu. Is one out of all proportion to the other. It's like a cross-check exercise. At present, the relationship is 240,000 and 350,000. The judge found that that was okay. But if the former sum of 240,000 were to be reduced significantly, the latter could be affected too. Another, perhaps more promising line of attack might be the decision to grant the injunction rather than damages in lieu. I mean, obviously, I accept this is a classic instance of the exercise of a discretion, but the decision might be seen as particularly harsh and betray an error of principle, making it amenable to a successful appeal. The injury to Beaumont, even on the common law damages assessment of £240,000, is relatively small. And Beaumont had also infringed Florala's rights of light with its own earlier development. The judge really didn't have any truck with that point. On the other hand, the area of Beaumont's property affected by the loss of light was some 30% of its space, which is quite large, whereas the agreed area of Florala's cutback was 515 square feet, which is not large. So it may be a fruitful line of attack. Florala is probably definitely going to try and overturn how the judge assessed the quantum of damages in lieu of an injunction. You will recall these were assessed at £350,000 as negotiating damages. The common law damages being, as I said, £240,000. Florala argued that for nuisance cases, damages in lieu of an injunction are conventionally based on diminution in value damages. The judge rejected this and gave reasons for the approach he adopted, but he may have fallen into error in so doing. Anyway, we will see what are the lessons for the future from Beaumont, and how can parties, or particularly developers, protect themselves. It's important to remember that following Coventry and Lawrence, the case I mentioned at the outset of the webinar, the perceived change in the approach of the courts to the grant of an injunction in a case of nuisance, whether you're talking about right to light or any other easement, may not actually be much of a change at all. It's still the position that the innocent party is prima facie entitled to an injunction. It's worth bearing in mind that Lord Neuberger was clear that where a nuisance is proved, he would accept that the prima facie position is that an injunction should be granted, so the legal burden is on the defendant to show why it should not. Lord Neuberger continued, it's right to emphasise that when a judge is called on to decide whether to award damages in lieu of an injunction, I do not think there should be an inclination either way, subject to the legal burden discussed above, so the onus is on the defendant. Notably, in the Coventry and Lawrence case itself, the Supreme Court did not overturn the grant of the injunction. Conduct is going to be hugely important to the question of whether an injunction should be granted and whether the defendant will discharge the legal burden if it's trying to argue that it should not be. The judge in Beaumont rejected Florala's argument that in order to grant an injunction, he had to be satisfied that Florala had committed a deliberate breach of Beaumont's property rights, knowing that that was what it was doing. The judge rejected that. He accepted Beaumont's arguments that there was nothing inadvertent or mistaken about Florala's conduct. It went ahead with the works, knowing that its rights of light surveyor had agreed that they would reduce the light at Beaumont's property, that Beaumont had a reasoned objection to this, and that it was carrying them out at its own risk because Beaumont had threatened to apply for an injunction. Florala could have modified its plans so as to reduce the interference, but it chose not to, due to its desire to make as much profit as possible from its development. Beaumont had, in fact, specifically put to Florala an alternative way of developing its hotel, with a cutback which would have avoided the interference with light, but Florala ignored this and carried on. The judge in Beaumont concluded that Florala had acted, quotes, in a high-handed or at least unfair and unneighbourly manner, and the injury Beaumont will sustain is not small, nor is it easily quantifiable. Bearing in mind the importance of conduct and openness, there are going to be implications for any insurance cover held by the developer. Insurance is, of course, a common method of rights to light risk mitigation. The nature of any approach to the neighbouring owner is going to need to be carefully considered in conjunction with relevant policy conditions. Insurers are going to place even more emphasis on agreed conduct provisions in policies that allow insured entities to negotiate with neighbours who object. Insurers are also going to need to see a profit share analysis of the proposed development so that they have the full picture on an award of damages. If negotiating damages are awarded in lieu of an injunction, they could be 1/3 of the profits associated with the additional massing. Do not forget tenants. This had a double role to play in the Beaumont case. It may be that Florala simply underestimated Beaumont's desire to pursue a claim because Beaumont was a tenant. Similarly, even though Beaumont knew that Florala had let the hotel development, it took no steps to join the hotel tenant as a defendant, even though it was seeking an injunction requiring a cutback and the hotel tenant was in possession. Historic agreements are rarely a get out of jail free card. In the Beaumont case, Florala placed heavy reliance on the right to light deed. It tried a reverse summary judgment application, which failed. That was the deed between Beaumont and the investor landlord. In 2016, as an opening shot, Florala was originally prepared to offer £150,000 for a release. So that was calculated on the conventional book value with a heavy uplift. But it changed its position when it saw the deed. Initially, it claimed the deed meant Beaumont had no claim whatsoever, which was obviously wrong. It then shifted its position to claim that the deed demonstrated that Beaumont was only interested in money and so was trying to extract a ransom payment. And therefore, said Florala, it should not obtain an injunction. It could not obtain an injunction, it said. That failed too. At the end of the day, conduct will be king. Despite being repeatedly warned by Beaumont's solicitors, Florala pressed on, and so it proceeded very much at its own risk. A developer will build at risk in the absence of a formal release. There is no need for panic following the decision, but it does confirm or reaffirm that the courts will be astute to strike down attempts to trample on the property rights of neighbours. Thank you.
Thank you, Philomena. I think I do agree with the point you make that we as insurers are considering. I think that agreed conduct will become more prevalent and or even more important, and we'll be, I think, having to consider the pricing around that as well. So we'll move to some questions from the audience now. We have a couple in already, so I'll start with that, but please, just a reminder to anyone, if you would like to ask any questions, you can so by typing them into the questions pane on your control panel. Philomena, are you okay to take some questions?
Yeah.
Excellent. So we have a question in from Jeremy Steele. Hi, Jeremy. Jeremy asks, do you think that law ought to give greater weight to the fact that, in practical terms, occupiers of commercial buildings almost exclusively on artificial light rather than natural light? Sorry, the text was a bit small there.
Yes, I do. I do think so. It's going to take a higher court, possibly, well, the Supreme Court, to make a decision of that nature. This is an illustration of the sort of technical aspects of rights to light, but it should be taken into account. The reality, I mean, I think there is a conceptual difference between, if you think back, I think the case of Mortimer and Bailey, if you think of a claimant in a residential property where a prominent living room is badly injured by a development, it's got to be conceptually different, in my view, to a commercial setting where the lights, artificial lights are put on. So I do agree with you, Jeremy.
Yeah. We have a second question in from Ashley Bevans. Ashley asks, if claimant not objecting to planning was not fatal here, what would be the planning decision, making process and considerations in whether or not to grant consent as part of court deliberations, i.e. if professional planners do not view loss of light as material in preventing the grant of consent, would a successful court order for loss of light entitle a challenge to grant of planning?
There's going to be a timing issue, I think, there. I mean, the way planning was dealt with in the Beaumont case was that, I mean, the defendant tried to take issue or make issue of the fact that Florala hadn't objected. The judge didn't think that was important or significant, but drew a distinction with the situation where what the claimant was asking for in a case was much bigger than what Beaumont was asking for, where he thought it could be a significant factor. I think it needs to be not objecting to planning. It's going to be need to be considered very carefully. I mean, it has to be considered very carefully following Coventry and Lawrence, where the existence of planning permission, while it's not a a trump card is something that is or can be treated as significant by a court being asked to grant an injunction in a nuisance case.
Yeah, actually, hopefully that answers your question. We have another question in. I think we'll limit these in a minute, but I have a question in from Robert McNally. Robert says, Philomena, as a practical step, what can a developer actually do to try and stave off a claim, I think that is, of acting unneighbourly when it wants to pursue a development in the face of what seems unreasonable and intransigent behaviour by a neighbour?
Well, I mean, the lesson to be learnt from Beaumont is one of openness. I mean, it's a risk. I won't quite say it's equivalent to playing poker, but one can see some similarities. But you don't, as a developer, do yourself favors if you're not open at every stage about what you're doing and why you view it in the way that you do, which obviously in the hypothetical problem you're putting forward is markedly different to how the potential claimant is viewing it. But you will be taking, obviously, professional advice, and you'll need to assess it in that context. It's a difficult path to navigate.
Yeah, I mean, obviously, I think with a lot of these cases, the conduct of the developer and other parties is definitely what we're seeing that's being taken into consideration. I mean, what would you say? What are in your view, the challenges there for the developer, I guess, with trying to act in good conduct, but also, as Robert says, pursue the development?
Well, have you properly assessed? I mean, have you properly assessed the impact that your development is going to have? And by that, I mean, there's a twofold aspect to that. There's the legal input. Are there legal reasons why what the proposed claimant is alleging isn't going to work? I mean, are there problems over the extent of the claimed rights? See, that's on the legal side. But then on the technical side, are you confident that you're looking at it in the way that a court will approach things? I mean, I think there's a tendency in these sort of adversarial litigation skirmishes to be quite defensive and maybe see things too constrained by your own assessment of the matter.
Yeah.
You need to be more open to other ways of assessing matters. I mean, psychologically, it doesn't like necessarily to bring this in, but in the course of, let's call it a grown-up discussion about the parties' respective positions, if you ought to and can concede a particular point, then it makes very much sense to do that. And you may well end up with a negotiated solution which gives you your release and enables the development to proceed. Whereas if you lock horns and won't discuss things, you won't have the same chance of achieving that outcome.
Yeah, excellent. I think we have one last question, and then I think I will close the floor for this session. Just a reminder to everyone that this session has been recorded, so if anyone would like to look back on anything or indeed share it with any colleagues, the recording will be sent out in the next couple of days. So the final question I have here, it's noticeable that neither party relied on book value calculations which had been prepared by the surveyors. Presumably this means that developers' profit calculations based on the cutbacks are now going to be prepared as a matter of course Traditionally, the surveyor's book value and multiplier assessment forms the basis of negotiations and insurance remedies. I don't know if you have a view on that, Philomena.
Well, I mean, I welcome the way the courts approach the common law damages. When you're looking at calculating profit, it's quite an interesting argument whether you input the conventional method or the sort of approach that the judge used in Beaumont.
Yeah. Okay, thank you. I think, as I said, we'll leave it there for today. Philomena, thank you so much for your time.
Steve,
and
everyone.
Talking through the case. Just thank you to everyone else for attending today. As I said, recording will be available, and if you do have any questions for Philomena or myself, please feel free to get in touch. If you respond to the communication that we sent out via the webinar, that will automatically come to myself. I can forward anything else on to Philomena as well. We are looking to sort of increase the number of webinars we do in the series. So hopefully we'll be putting a few more in. If anyone's interested in any particular topics at all, then please do let us know, and we'll definitely consider that. So we can say thank you again to everyone. Thank you, Philomena, and look forward to speaking to you all again very shortly.